and thank you for joining us today. My name is Yongki. I am a senior associate at Scott Legal PC. Today's webinar will focus on how to move from a non-immigrant visa to a green card in the United States. We are very fortunate to have our firm's managing partner, Ian Scott, as the speaker for today's presentation. I will begin with the overview of family-based green card categories, and then Ian will discuss more detailed practical guidance on employment-based green card categories. Before we dive in, let me briefly introduce our firm and go over a few housekeeping items. We are a full-service immigration law firm, and we offer representation across a wide range of practice areas, including E2, O1, TN, L1, H1B, and all types of employment-based and family-based green card cases. That said, we are particularly well known for our work in the complicated green card cases, and we have built a strong reputation through our comprehensive approaches and strategies. So we have processed thousands of these, complicated and cases, and then we have been able to secure approvals for the vast majority of them. At the end of this webinar, we'll send you several useful tools. A copy of the PowerPoint presentation we'll go through today, a link where you could download the guidelines with more details on visa options, and another link to sign up for the additional webinars. A link to webinar recording on YouTube. We encourage you to subscribe and hit the notification button as we regularly post immigration related videos. And a link where you can set up a private consultation with our team. Finally, for any questions, please type them into chat box or Q&A box. We'll address all the questions at the end of presentation. And with that, let's get started. So how does the green card system work in the United States? The first thing, I guess we need to talk about how green card system works, so that's what, and then we can talk about how there are how many subcategories and categories out there in the family-based and green card case. U.S. green card system is quite different from other countries. As you probably know, for example, in Canada, they use a point-based system, which gives points all different things like education, language abilities, work experience, and even age is kind of point, and other factors. Another example is like United Kingdom is quite famous, as you know. In UK, it's not every single visa though, but certain types like work visas will let you apply for the permanent residency after 5 years of residence over there. So it's kind of automatically leading to your permanent residence in UK for that particular types of visas. But unfortunately, United States immigration system does not work that way. Instead, there are several green card categories that you have to simply pick and choose and apply for one based on your personal eligibilities. So for example, even if you live in the United States for 10 years with your TN visa or E2 visa, it does not automatically lead to a green card or give you any eligibilities based on how many years you have been living in the United States. The U.S. green card system is primarily broken into two ways. One is the family-based, and the other one is employment-based. Under the family-based, the immediate relatives category is for the U.S. citizen's spouse, unmarried children under the age of 21, and parents if the sponsoring student is over 21. And the preference categories have multiple subcategories. For more detailed information, you may look at the Department of State's visa bulletin. But a couple of good examples for these preference categories are spouse of U.S. permanent residents and brothers and sisters of U.S. citizens. And these are the kind of well-known preference categories. Employment-based categories are broken into total 5 big categories from EB1 to EB5. EB1 is generally known as extraordinary ability case. EB2 is for national interest waiver, and PUM case is where the application process go through the Department of Labor first before you submit the application to USCIS. EB3 is also through the PUM-based company sponsorship. EB4 is religion-based, and finally EB5 is investor-based. For these employment-based categories, Ian will address more detailed information later on our presentation today. Moving on. So family-based green card case. The immediate relatives are the most popular way to process your foreign national spouse's green card case. The preference-based categories have a total of 5 different categories, from F1 category to F4 categories, but 2 well-known examples are the ones I mentioned before: spouse of a U.S. permanent resident and brothers and sisters of U.S. citizens. A big issue of these preference-based categories is that these cases are processing by and governed by a visa bulletin monthly announced by Department of State, which causes backlogs a lot. And this means while the green cards for the immediate relatives are always available, the green cards for the preference-based categories may not. So depending on which countries you are from and or which category you are applying for, there may be some significant delays before the green card is finally approved. A good example is F4 category, which is for the brothers and sisters of U.S. citizens. This category is kind of notorious in the U.S. immigrant system that you need to wait almost 18 years nowadays. Very long time. That's why we preference-based categories are quite taking long time. The reason is that the visa bulletin is governed by the limited number of annual green card caps. So it even applies for the employment-based green card categories as well. Each employment-based green card category has annual cap of how many green cards can be issued. Once particular categories reach the annual cap, then the application may be experiencing some delays, and that's why it is important to check the monthly visa bulletin announced by Department of State when you are preparing your green card application. Next, let's talk about the process for the family-based green card cases. The review process by the government is basically broken into 2 parts. First part is whether petitioner and beneficiaries really having bona fide relationship. If it is marriage-based, then marriage relationship, or parents-child relationship, or sibling relationship. That's the whole point they are looking in the first part for the I-130 petition. And the second part would decide whether the case will be processed at the consular or adjustment of status inside the United States. If beneficiary is outside of the United States, then the approved I-130 case will be transferred to something called National Visa Center, where the beneficiary needs to submit the required civil documentations. And then case will be finally transferred to the U.S. Embassy in the country where the beneficiary is currently residing and for the immigrant visa interview. So it's like 3 steps: USCIS, National Visa Center, and U.S. Embassy. That's called the consular processing. But if beneficiary is inside of the United States, then the beneficiary may apply for the adjustment of status by filing Form I-485 with the USCIS. just one stop for the application, and once USCIS approve the case, then beneficiary will receive the green card. However, some situation requires additional processing. For example, when a marriage-based green card case is filed, USCIS will impose a condition on the green card if the marriage has not been more than 2 years. So the beneficiary need to go through the additional processing, which is called I-751 condition removal processing after 2 years of the issued green card. So that's pretty much how family-based green card case works. With that in mind, let me turn you over to Ian, who will guide you through the next part of our presentation, and will cover more details about employment-based green card case, particularly EB-1A extraordinary ability and EB-2 national interest waiver. So please stay tuned.
Perfect. Thank you very much, Yongki. And yeah, so as Yongki mentioned today, the focus is on moving from a visa to a green card. And as Yongki just mentioned, one key way that people do that is through family, and that's over multiple visa categories. So it could be TN, H-1B, E-2, and they, for example, meet a U.S. citizen and then obtain a green card, or as Yonki mentioned, the preference-based categories, which unfortunately all of those are delayed, but there's a delay for all of them, and the longest one being the one that Yonki mentioned, the sibling category. But a large number of our clients do move from a non-immigrant visa to a green card through that route. And then as well, a large number move through the employment route. And the employment route, as Yonki mentioned, goes EB1A, EB1 through EB5, and we don't do EB4, but these are different ways that people get green cards. And one is that the person has risen to the top of their field. And it's extraordinary ability, and this is EB1A category. And now this one's an interesting one because typically the people that we see moving to EB1A, they would be people who maybe had an O1 first, and there's an extraordinary ability category of an O1 that is similar to EB1A, but it doesn't have to, if the person doesn't have to have had an O1 before applying for EB1A. If someone has risen to the top of their field and they judge that by the individual having met at least three of the following criteria that are listed below. If you meet more, that's better because once you've met the three, then the government does another analysis that looks overall very subjectively at whether or not they feel that you have risen to the top of your field such that you should get the green card. But you just used a couple of these as an example. If you show evidence that you have a high salary, then the government is using that to say, well, if the person is making a lot of money, then they must have risen to the top of their field. Same thing if with judging the work of others. If you look at the television show American Idol, the judges are people who are already, experts, famous singers in their field. And that's why they were selected as judges to judge others. So those are just two examples, but all of them are really getting at the same thing, where they're trying to show that the individual has risen to the top of their field. The next category that we're going to take a look at is, and just before I move to EB2, and we can stay on the slide, but just another one that isn't on a slide, but I think it's worth mentioning is some people move to a green card through EB1C. So EB1 is broken out into EB1A, EB1B, EB1C. Now, EB1C is a category where the individual is a manager or executive, and they have worked abroad for 1 year in the last 3 years, and they have some other requirements that they have to have executive or managerial capacity. Now, people who move to a green card under EB1C, they were typically on an L1. Again, there's no requirement that they had to have been on an L before, but they're typically on an L1. And once their role expands in the US, so it might be that there are a lot more employees, or the role expands in the US to their executive or managerial role, then they might be eligible for applying for EB1C. And then the next category, EB2, this is EB2 as a category is broken out into two parts. So it's EB2 national interest waiver and EB2 perm, which we're going to talk about after this one. Now, the EB2 national interest waiver is a green card category that really says that the person is coming to the United States to do something, they're coming to the United States to engage in some endeavor. And then the endeavor that the person is coming to the United States to engage in order to get an EB2, there would have to be a conclusion that the endeavor was of national importance to the United States. So it could be that the endeavor creates jobs. It could be that there's some other economic benefit. It could be that the endeavor is something that the government finds is important. So someone coming to do cybersecurity work or implement some innovative new technology. But that's the crux of the national interest waiver. And then you do have to show that you're well positioned to advance the endeavor. And then the government has also said that they believe that it's in the national interest to protect U.S. jobs. So you have to give reasons why what you're coming to do is more important than protecting U.S. jobs. Now, I just skimmed over this because this particular webinar would go through all different green card categories. We do have separate webinars on EB2 national interest waiver because it is a complicated area and there's a lot to cover there. Same thing with EB1A. We have separate webinars just on those. And certainly you feel free to sign up for those. But for the purposes of this webinar, we just wanted to point them out in terms of ways that people can move to a green card. It is a very high bar. So sometimes we get consultations where people have done very little and they think that the national interest waiver is available to them, but it is a very, very high bar. Um, and the other kind of thing to think about with EB2 national interest waiver is, and this is for all EB2, you do have to meet the threshold requirements for EB2, which are that you have an advanced degree. So that is a bachelor's degree plus 5 years experience or a master's degree or higher, right? So that's what an advanced degree is. And then, or if you don't meet either of those, then you have to have what's called exceptional ability. So there are a list of seven criteria, and you have to meet at least three of them. These aren't the same as the extraordinary ability criteria. These are exceptional ability. These are lower bar, because, as I said, they are kind of just based on threshold requirements to make it into the EB2 category. So when you're doing the EB2 category, the first thing that you do is look to see if you've met the threshold requirement. So for example, let's say you just have a high school degree, you could possibly still do EB2, but you would have to qualify under the exceptional ability criteria. If you have a master's degree and the master's degree is related to your area of endeavor, then you could qualify there. And qualifying means that you just move to the next step of proving that what you're doing is in the national interest. The next slide goes over how you apply for both of these. Now, both of these, the EB1A and the EB2, both of them have the ability where you can self-petition. So you don't need an employer. If you have an employer that, the employer can be the petitioner, but you don't need an employer. And what happens here is it's a two-step process, and you file an I-140 form, and the I-140 is the form that is the objective form that shows that you've met the criteria. So for example, under EB1A, the form that shows that you have met at least three of the 8 requirements, and you're making an argument that you have extraordinary ability. Similarly, that for the EB2, then Y140 is showing that you actually A, have met the threshold requirements, and then B, have met the other requirements related to your endeavor being in the national interest and being well positioned to advance the endeavor. Then you have to, and this is really the case with all green card petitions. You have to decide whether you're going to be doing adjustment of status or consular processing. If you're outside of the United States, you only have the option of consular processing. If you're inside the United States, you can file an I-485 petition, provided that your category is current. And not all categories are. Like EB2 is not current for any country, and EB1A is current for most countries, but not India and China. So if it's similar to the family base that Yongki talked about, if the category is current, then you can file the I-485, and you can when you file the I-485, you can file the I-765 and the I-131. That's the work authorization and travel authorization. And once you file those, you have a lot of the benefits of the green card until the green card is actually approved. So you're in a period of authorized stay. You can stay in the United States, and you will, in 6 to 9 months, get work authorization and travel authorization that allows you to travel as well. The next category we're going to talk about is EB2 and EB3. So this is the EB2 regular rather than national interest waiver, and EB3 and perm. So what this is when a company wants to sponsor you for a green card. So that's under two categories, EB3 being unskilled workers and EB2 being professional and skilled workers. And this is where you do need a company to sponsor you. And the company is really going through a three-step process where they're working with the Department of Labor to come up with how much the job should be paid, the job description, recruiting. So actually putting an ad out there saying, here's a job that's available and here's the pay. People apply for the job, they interview them, even though there's no real job available. Because what they're trying to prove is that the company can't find a qualified U.S. worker, because if they find a qualified U.S. worker, then they're required to hire that worker, or probably better said, they're not permitted to hire the foreign worker. So that's it. It is quite a process. Usually takes over a year for that process, and there are a number of things that kind of can make that process more difficult, like if you include a foreign language requirement, for example. And again, this is with the Department of Labor, not USCIS. And then once that's approved, then you can file the I-140. And the I-140 is, for most perm applications, the I-140 at this stage is going to be more straightforward because it's just going to be based on the job, right? So if you're saying that you need a bachelor's degree for this particular job, then that's what you're going to be proving. And then because you already have the certified perm from the Department of Labor. And then the same discussion occurs with the I-485. So you're going to decide whether you're doing the I-485 or consular processing. Normally, if you're going through this process, it's going to be the I-485 because just generally speaking, people who are going through the perm process usually are working for the employer already in some other capacity, like maybe H-1B or TN or some other capacity. They're usually working for the employer already. So as if they're already working for the employer, if you're doing consular processing, typically we do consular processing when the person's outside of the United States. But there could be the same discussion here with respect to consular processing and adjustment of status. And the last category that we're going to talk about, employment-based category anyway, is the green card related to EB5. And the EB5 can be done either by investing in a regional center. So a regional center might be a situation where you have a hotel that wants to raise a lot of money, and then they use the regional center program to attract investment. And if they create 10 full-time jobs, then the person can get a green card, or people can get a green card. The direct investment would be somebody that is starting, that has their own business or investing in a business. And the investment amount is that the amount they have to invest is either 800,000 or 1,050,000 in a new commercial enterprise. That's any enterprise that's been established after 1990. And the difference between the 800 and the 1,050,000 is if the business is started in a targeted employment area, so an area where the unemployment rate is 1.5 times the national average, or in a rural area. And it does have to be investment that is invested into the company. So it can't just be money that's accumulated over time. A lot of our E2 clients move to green cards through EB5. But we do have clients that have all sorts of non-immigrant visas that move to a green card through EB5. There's a source of funds analysis, so you do have to show where the money is coming from, and that's quite an extensive analysis. It's more like an audit. The government treats it more like an audit, so it's not just a general overview, and it's much more significant than E2. And the investment does have to be some type of equity, so it can't be debt or anything like that. In order to get the green card, you do have to create 10 full-time jobs. And, whether it's direct investment or regional center, it has to be 10 full-time jobs. And the investment does have to be linked to the job creation. So that's what timing really matters regarding when you invest and the creation of the 10 full-time jobs. So for that reason, you can't buy a business. Like you can't say, okay, well, I'm going to give a seller $800,000. I'm going to buy their business and then get a green card, because the money just went to the seller. The money would actually have to be invested into the business. And You definitely want to make sure that you're documenting the workers because the workers do have to be full-time workers, and they have to be green card holders or U.S. citizens. And the filing, this is a three-step process where we file an I-526 petition. We went through we've talked a lot about the I-485 and consular processing. So depending on whether or not the category is current, you'll be able to do one of those. And then once you get the green card, it's a conditional green card. And once you've had the green card for 2 years, you have to file documentation to remove the conditions. And that's an I-829 document file. The next, here's some other options. Diversity lottery, that's a program. It's currently paused, I believe, but it'll be opened up again. And that's, they just randomly select from a bunch of different countries. There are humanitarian-based green cards, whether it's asylum or helping police solve a crime, but there are a number of those. And then, one day we hope that we'll see some type of immigration reform. Timing is really important with these petitions, especially if you have a non-immigrant visa and you are in the United States, because you have to make sure that you're able to renew it, especially since, and that you keep your underlying status, especially since the EB-5 in particular is a petition that takes a long time. It can take 4 to 5 years for an EB-5 petition to be approved. And so you have to just make sure that you are maintaining your underlying status. And if you do have to travel, you have to make sure that you have the appropriate authorizations. And when you have the underlying status, someone that's on a TN visa has to be more careful than that's on an H-1B, for example, because an H-1B is a dual intent visa, which allows people to have the dual intent, whereas TN, you have to be much more cautious with respect to renewal and travel and things like that. And sometimes people do have parallel green card strategies. We've had people who apply for a green card and under EB-5, for example, and then they meet a U.S. citizen, and then they apply for the green card under that, and that's, a much better option. And really planning is the key for this. Perfect.
Okay. Thank you, Ian, and that was very informative. And with that, let's go ahead and take a look at the questions. We don't have any questions.
Perfect.
Okay.
Yeah, but
Yeah.
we can always, I know it's a lot of material, so
Yeah, yeah. Okay, thank you all for joining us today. We hope this webinar has been very helpful for your journey to green card in the United States. If you have any additional questions, please feel free to visit our website and schedule a consultation with our team. We look forward to seeing you at our next webinar. Thank you.
perfect. Excellent. Thank you. Bye-bye.